Hey guys, I am here. Hey Vicky, hey Coco, Lady Courtroom, what's going on? All right, let me Hey Sharon, hey Nosy, I didn't even know you was in here. I just sent you a message, and you snuck up on me. You snuck up in here. Happy Good Friday, everybody. Gotta get my water in. Hold on a second. Happy Good Friday. Gotta get my eyes. My ice. My ice falling all over the place. Hey, Toria. Hey. All right, what we're going to do is we're going to start some footage tonight. I've been missing out. I'm just going to show you some footage. I'm going to show you the footage from the whole from the other day. And the footage for today. Let's get started. Guys, you know that the trial is still going on, and we are like what? January, February, March, April, fourth month, and still no jury selection. But there's a whole bunch of hardship. The judge did 4 hardships today, and then he did a lot of the other things that was like needed to be taken care of. He did give a schedule for the motions, because there's a lot of motions out there, a lot of motion. And I'm gonna bring one up for you. And this is a motion that they put in earlier. Hold on. Not that one. How is everyone doing? Everybody's doing okay. All right, we got quite a few motions that hold on. There's one specific motion that was submitted today. Not today, a couple of days ago, and it was one motion that the attorneys all adapted to it, and it was submitted by Mr. Williams' attorney, and it was a plea in bar. So I'm going to check out what a plea in bar actually mean, and then I'm going to read the motion, and then we're going to see the footage for what we have for this week. So I'm going to bring this up to you guys. 1 second. It's a plea in bar. Okay, hold on. Just 1 second, guys. I gotta go out, come back in. Cancel. All right, here we go. Go pull that one up. Choose. Here we go. Don't forget, guys, I have a few of you guys. I got something to show y'all tonight. Trying to find a way to place my cup. Got something to show you. I hope you're not gonna be like too sleepy for me to show you what I gotta show you tonight. Got some stuff to show you tonight, y'all. It's gonna be like, what? Really? Oh my God, for real? That's what you're gonna say. They're gonna have those kind of like ideas. This is like for later on. Members only. Members only. Hold on a second. Let me just download this. Download this. And we're going to read this motion that was submitted by Mr. Williams' attorney. It's about Jeff. What, this live? Yeah, this is live. Is about Jeff. Yes, it is. This live is about Jeff. All right, this is, 1 second. Hold on. Second. All right, this here I'm going to pull up for you guys. All right, this is the motion that. Oh, you talking about the members only stuff? No. This was not about Jeff. This one's about Mr. Kelly. That one's about Mr. Kelly. Now some stuff from Mr. Kelly. And all right, let's get started, y'all. This is the motion that Mr. Williams' attorney, Mr. Steele, submitted the other day in regards to Mr. Williams' plea. And listen to this. This here, all the attorneys adapted this. All the attorneys on deck has adapted to this motion, okay? Here we go. United States. I'm sorry. Oh, I'm so used to saying United States. Oh my God. All right. Where my girl Kim at? All right, let's go. Let's do this. State of Georgia versus Jeffrey Williams et al., defendant, Indictment number 22SC183572, Judge Glanville. Plea in bar, joint motion to strike all predicate acts from count 1 that have already been adjudicated by a court of competent jurisdiction. Competent jurisdiction. Now come Mr. Jeffrey Williams and all co-indictees by and through undersigned counsel hereby file this plea in bar. Hold on a second, y'all. Hold on. Sorry, something going on here. Hold on. All right, I'm sorry. I'm back, guys. Okay, hold on. Let me get back here. All right, let me go ahead and read this for you guys. Now come Mr. William and all indictees by and through undersigned counsel and hereby file this plea in bar. Joint motion to strike all predicate act from count 1 that have already been adjudicated by a court. By a court of competent, hold on a second, I'm breathing hard, jurisdiction in the above referenced case. In support of this motion, Mr. William and all co-indictees show as following. 1. Mr. William is innocent of all crimes. In the above referenced indictment, Mr. Steele is innocent of all charges made against him as well. Number 2, Mr. William has wrongly indicted in count 1 RICO conspiracy. See Bill of Indictment count 1. Mr. William has never been convicted of any felony, but has standing to bring this motion because the grand jury indicted Mr. William as being a member of a RICO conspiracy. This is the same assertion is made by all co-indictees, including but not limited to Mr. Stillwell. Number 1, based on the information and brief on all indictees joint in this plea in bar motion to strike. Several predicate crimes that are charged in count 1 have already been adjudicated by a court of competent jurisdiction and thus must be redacted from the indictment. Basically, they're telling them that, remember I was telling you guys that there were cases in this here that's involved, that these people have already been, most of them are serving time for those, and some have already served the time, and they have included it into this case. So it's basically double jeopardy in some cases because it been adjudicated already. So why are you bringing it back and putting it part of a RICO? Not sure why they did that, but that is something that has happened. Okay. All right. Number 4, Mr. William and all other indictees have standing to bring this plea in bar motion to strike because the predicate crimes of others are being sought to be used against all since the grand jury charged this as a RICO conspiracy. So this part is saying, like, if John Doe robbed somebody, got indicted, and it was John Doe that did this crime. It was none of the other people. They're saying now that you cannot include John Doe's crime into this RICO because this has nothing to do with these other individuals. You get what I'm saying? They have nothing to do with them. So therefore, this must not be part of it. This was stuff that happened prior to this. So just because a grand jury have indicted them does not mean that this is supposed to be here. And remember what Timothy said, that you can indict a ham sandwich, meaning that an indictment does not mean guilt. It just means that they're putting everything together to try to get some sort of a case to come to court. Okay, so that's basically what they're saying is, like, these people have already been, this is one person's crime. This is not everybody's crime. It's just one person who committed this crime prior to even Mr. William not even knowing this person, but they including this as part of Mr. Williams' case as well because they did a RICO. So therefore, RICO is including everybody that's supposedly part of this organization, the criminal enterprise, whatever. Okay, that's what that one's basically saying. Number five, OCGA 16-1-7A provides that when the same conduct of an accused may establish the commission of more than one crime, the accused may be prosecuted for each crime. However, he/she may not be convicted more than one crime if one crime is included in the other crime, or 2, the crime differs only in one is defined to prohibit a designated kind of conduct, general, and other prohibit specific instance of such conduct. Okay, you got that one? Basically, it's saying that you cannot convict of someone for the same crime more than one time. Right? It says, however, she may not be convicted for more than one crime if the crime includes the other. If it coincides with each other, it should not be considered more than one crime. That type of thing. Right? Only if the crime is different, then you can charge it different, for each crime. But if it's the same, no. Okay. Number 6, by its term, OCGA 16-1-7A1 applies only when the same conduct is an issue and thus substantive double jeopardy. Remember, I was telling you double jeopardy, charging them for the same crime. Okay. Jeopardy law protects the criminal accused from multi-punishment when his or her crime arises from the same conduct. Typically, the same conduct refers to acts committed against the same victim at the same time. You can't come back and get them for the same crime with the same victim. And that's what they're doing. They putting these people have already been convicted and this crime has been addressed and it was in the right jurisdiction. And now they're coming back doing it as a RICO and then charging the same crime again for something that has been already remedied. Okay. All right. So that's what basically it's just repeating itself, but in a different term. So they gave a case law on that as well. Silla versus State, Georgia, and then case number is given that. Then they give another case number here. It says in Austin versus Cohen gave a case number. The Honorable Appellate Court explained that the doctrine of collateral estoppel prohibit the re-adjudication of an issue of law or fact already adjudicated between the parties and its privies where that issue is essential to the judgment. Collateral estoppel and issue preclusion prevents the re-litigation of an issue that is identical to the one decided in prior proceeding involving the same parties. The doctrine of collateral estoppel prevents an issue previously litigated and adjudicated on the merits to be relitigated even as part of a different cause of action. Hold on a second, y'all. Okay, I'm sorry. Keep getting these disturbance. Okay, this doctrine prevent litigation from. Hold on. The doctrine of collateral estoppel prevents an issue previously litigated and adjudicated on the merits to be relitigated even as part of a different cause of action. This doctrine prevents the litigation from splitting charges against the same party into series of different cases. Oh, all righty. So y'all, you get it, right? They're saying that basically for the same crime, you can't try to split it and do it in a different case. You're supposed to be handling it all at once. That's basically it. That's my interpretation of that one. Furthermore, Austin versus Cohen Supra teaches that the doctrine of res judicata mandates the litigation must be final and plus a judgment of the court of competent. Oh, hold on. Somebody's sending me. Competent, whatever, jurisdiction shall be conclusive between the same party and their privies as to all matters put in issue or which under the rule of law might have been put in issue in the clause wherein the judgment was rendered until the judgment is reversed or set aside. Therefore, the doctrine of res judicata bar a subsequent action when the following requirements are met. Number one, The first case has had to involve an adjudication by a court of competent jurisdiction. 2. The two action must have an identity of party and subject matter. And 3. The party against whom the doctrine of res judica is raised must have had a full and fair opportunity to litigate the issue in the first case. Number 9. In Austin versus Cohen, Supra, our appellate court explained that because Mr. Cohen had pleaded guilty to conspiracy to commit wire fraud in violation of federal law, the civil RICO case could not again alleged that Mr. Cohen committed the same predicate act that was previously adjudicated based upon the doctrine of collateral estoppel and res judica. These, don't ask me what these stuff mean, okay? Because I don't. I'm not an attorney. In Bethune versus State, our appellate court held that a RICO conspiracy case cannot allege, charge, or use predicate crimes that were previously adjudicated. As shown above, this proposition of court is based on statutory double jeopardy pursuant to OCGA 16-1-7B and OCGA 16-1-8B. Res judica, collateral estoppel, and the United States Constitution, as well as the Georgia Constitution. See Harrison v. State, and I give a case law on that. Number 11. Thus, where the criminally accused were formally prosecuted and sentenced for certain criminal offenses, the state cannot thereafter prosecute the same accused for racketeering based upon the same predicate act criminal conduct. Oh, y'all know that one. That was an easy one. In the case at bar, the grand jury of Fulton County charged several co-indictees, some of whom are on trial and some of whom are not on trial because they plead guilty and have been severed from trial with predicate crimes that have already been adjudicated. Every one of those previously adjudicated predicate crimes must be stricken from above reference indictment and not used by the prosecution in this case. Although Mr. William and other co-indictee may and may not be charged with a prior conviction, it is anticipated that the Honorable Court will charge the jury that the individual co-indictee does not have to commit the specific predicate crime to be convicted of a RICO conspiracy if he is a member knowingly, freely, and voluntarily of the supported RICO conspiracy. Hence, Mr. William and all co-indictees have standing to bring this plea in bar motion to strike. As for Mr. Steele, the indictment alleges several predicate acts involving him which have already been adjudicated, clearly implicating collateral estoppel, res judica, and both constitutional and Georgia statutory double jeopardy. Wherefore, Mr. William and Mr. Steele respectively ask the Honorable Court to hold a hearing on this plea in bar to strike, and at the conclusion of the same, ask this Honorable Court to grant the above request relief. This 6th day of April, 2023, respectively submitted Brian Steele, Keith Adams, etc. Max, Schalt, etc. Okay? All right. So, any questions, my good people? Any questions? Any question? No question? All right, Diego. So, Diego, okay, what it means they can't come back and try to get him for stuff that has already been handled before. That's what it means. That's what it means. Will we see the king free anytime soon? I can't answer that. They got to go through trial. I can't answer that. Hey, Sierra. Bobby says he's coming home. Hey, Miss Sylvia, shopping. See you live again. Yeah, I'm live again. I'm just showing some coverage, some things from this week. So y'all, let's go ahead on and show these. I know people have been missing it, and folks probably don't think I'm got some footage, but I do. I do have some footage. All right, let's get going. Let's get going here with these footage. My throat's itching. Y'all. When I tell you my throat's itching, it's itching. And I promise I wasn't going to talk through this today, since you guys haven't seen this in a while, so I won't talk through it. I'll give you guys a chance to watch. This is all from today. Sorry. It said all rise.
The count is now in session. Honorable Chief Judge, you're glad to preside. Good morning, ladies and gentlemen. Please be seated. All right.
Ooh, somebody just belched. I heard that. I heard somebody belch.
All right, ladies and gentlemen, good morning. Let me go ahead and call roll in the matter of the state of Georgia versus Khalif Adams et al. In 22 SC 183-572. Mr. Beebe and Mr. Partridge, good morning, gentlemen. Mr. Stillwell and Mr. Botts, good morning. Mr. Farley and Mr. Menendez, good morning. Mr. Williams, Mr. Steele, Mr. Adams, good morning, gentlemen. Mr. Mender and Ms. Fagan, good morning. Mr. Kendrick and Mr. Weinstein, good morning. Mr. Huey, Mr. Matthews, good morning, or I should say Ms. Manifood, good morning. All right. Mr. Myrick and Ms. Bernard, good morning. All right, Mr. Nichols and let's see, Mr. Gardner, good morning. All right. All right, Mr. Adams and Ms. Callan, good morning. Mr. Blaylock and Mr. Hill, good morning. Mr. Dorsey and Mr. Jimenez, good morning. Or I should say Ms. Hyman, I apologize, good morning. Mr. Ebinger, Mr. Johnson, good morning. Or good afternoon. Okay, all right. Mr. Ryan and Ms. D. Williams, good afternoon. All right. Ms. Love, Mr. Smith, good afternoon. Good afternoon, Mr. Randolph. Hi. Ms. Von Kelsch is has an appointment outside today, and she will be back with us next week. There are 4 people to be examined for hardship today, and once we complete those 4, I'm going to talk with you all a little bit about scheduling, but that's kind of the order of merit today. Ms. Fagan, I know you asked yesterday, and it was a good question in regards to consolidation and efficiency, which I'm all for. However, we have examined most of all of this to answer your question yesterday, we put a pinpoint on your question yesterday. The reason that I think you've been clocking pretty well the number of people we have left. We have scheduled these particular people today and over the next couple of days next week in order to accommodate their various schedules, meaning that they're either on vacation or they had medical procedures or some other things. So Ms. Von Kelsch and her team, that's why these are the last remnants and folks that we were not able to get on the other days that we could have probably examined them and gotten through with that. So it's not anything that anybody has to deal with. It's just, that was just I know it would be more efficient to do them all in one day and just get rid of them, but that the schedule just wouldn't permit that. So that's why we're kind of handling the stragglers kind of right now from this particular group. And that's why we're not doing that many hardships for the next several days, but that does exhaust the pool of hardships from this particular group. So that is by way of explanation as to why we are doing that. Ms. Fagan, does that satisfy or otherwise augment the explanation I gave you yesterday? I mean, please don't count judges' calendar time. That's one of my only pet peeves other than gum. But because I have other business I got to take care of. So, okay, all right. Okay, so with that, Mr. Randolph, let's go ahead and call in juror 944, please, sir.
Yes, John.
Thank you. Juror 944, good afternoon, sir.
Good afternoon.
Sir, do me a favor, speak directly into the microphone, pull your chair up as close as you can so we can all hear you, okay?
Yes, sir.
All right. Juror 944, you have identified for hardship, or we either identified you, and the reason given was work-related. Is that correct?
Correct.
All right. Juror 944, we have some information about you that is self-provided. So you gave it to us. So do you work in corporate finance for an organization called Courtroom?
That is correct.
How long have you been with them, sir?
Since graduating college, so it's been 7 years.
Okay. Are you a salaried employee, sir?
I am.
How much did you make last year?
My salary is $130,000.
All right. And do you happen to know what Cortland's juror policy is?
I do, and I have a copy of it with me.
Can you hand that to Deputy Ingram for me, please? Thank you, sir. All right, I'm going to include this particular juror 944's exhibit as the next court exhibit in order. Juror 944, it looks like that the policy indicates you get paid up to 5 days between those two things. Travel, plan for maybe about 3. Would that also affect your ability to be fair and impartial both to the state as well as to each individual defendant?
Yes.
Ms. Love, anything else, madam?
No, Your Honor.
Anything on behalf of any individual defendant?
No, sir.
May I excuse juror 944 for hardship?
Yeah.
Sir, I'm going to excuse you for hardship and wish you all the best, okay?
Thank you.
Thank you. 1048, Mr. Randolph.
2022.
Yes, ma'am. Like a family discussion, like a discussion with your family or a text message or anything like that showing that, hey, we're planning or talking about this trip?
Sure.
Okay.
Can try and find something like that.
Your Honor, while she's looking, did the summons go out on the 2nd?
Second, yes, ma'am.
Thank you.
So she may be in that, we may have an issue with her anyways, but just to complete the record.
If I can't find anything like
Say
that,
again?
if I can't find anything like that really quickly, I have the date of purchase.
And now you said that was the first?
Yes. And then I got the confirmation.
Can I see that?
On February 2nd. Here's that.
Show that
Oh,
to
sorry.
Madam, where is it?
Yes.
Where does it show that you purchased this on the first? I'm gonna hand you back your phone.
Sure. I don't know, but I'll try and find a text message. Here's one of the first emails from my family from 2022.
That's
starting to
fine.
talk
Let's take a
about
look at that.
about the trip.
Okay, councils, I will note for the record that she did purchase, it shows a purchase for that particular itinerary she's talking about on 2 February, and that's when the notices went out for this particular period of, and then I'm also looking at a series of messages showing that they started discussing this trip in May of 2022. There's a series of emails that talk about that. So between those two things, councilors, is there any reason that I need to continue any further examination of juror 1048, or may I excuse her for hardship?
No objections or excusal from the state.
Okay, all right. Madam, I'm going to excuse you for hardship and wish you all the best, okay?
Thank you.
All right, thank you. I assume that you have some customary expenses that go along with that mortgage, like utilities and other related expenses. Is that correct?
Yes,
Jonah, do you have a car note or car insurance?
car insurance.
Okay. Any other extraordinary bills that you pay that I should know about?
Other than credit cards, no.
How much in credit cards are we paying per month?
Approximately 200.
Okay. And how much do you have in checking and savings, sir, at this point?
5,000 and probably 7,500.
Okay. How much did American pay you last year in terms of salary?
100 and
Or hourly, your hourly rate from last year? What was the total compensation?
hourly rate was 75.
Yes, sir.
Annual rate was maybe 110.
Okay, about 110,000?
That is correct.
Okay, all right. Would it be fair to say that if you were with us about 6 months, would you lose at least $55,000 in income?
Yes,
Would you also have to expend some of this almost $12,000, $13,000 you have in checking and savings to pay your ordinary customary bills, your mortgage and other payments, credit cards?
yes,
Would that put you in financial peril or concern?
yes,
Would that financial peril or concern affect your ability to come into the four walls of this courtroom and give this case and its parties your undivided attention?
most definitely.
Would that also affect your ability to be fair and impartial both to the state of Georgia as well as to each individual defendant in this case?
Yes.
Ms. Love, anything else, madam?
Not from the state.
Anything on behalf of any other individual defendant? May I excuse juror 1169 for hardship?
No objections from the state.
All right, sir, I'm going to go ahead and excuse you for hardship. Wish you all the best, okay?
Thank you.
Bariatric surgery fairly soon, correct?
Not me, sir. My mom.
Your mom, okay, all right. And is that who the medical issue is for?
It's a little complicated. My apologies. I'm having some medical issues. My mom's having bariatric surgery, and my dad has cancer.
What type of cancer does your father have?
Esophageal. And I put those in three. I stapled.
I
Three
got you,
different
okay,
packets.
I got you.
Yes,
So
sir.
your mom is having surgery on the 12th, is that correct?
Yes, sir.
This month? All right, and where does she live?
She. I live with her in East Elena.
Where does dad live?
Dad lives in Colbert, Georgia.
And are you otherwise seeing after him at this point in time or what?
I'm more so seeing after my mom because I live with her. But I do want to be there for my dad as well. He's going to have a surgery after his treatment for cancer as well.
So right now he's being treated for this cancer
Yes.
and he's supposed to have surgery. When's that supposed to occur?
He's supposed to have surgery likely in June.
Okay. All right, and then what's going on with you?
They're still trying to figure out some things, but I'm scheduled for a CT scan, a sleep apnea study, a sleep study, and also a hearing test. So far, they think that I have what's called irritable bowel syndrome, and also it seems likely that I might have sleep apnea, Your Honor.
Okay, all right. When are you supposed to be scheduled for this sleep study?
The sleep study is
My phone is
on, I
acting
believe
up.
it's the the sleep study is May 4th, I believe.
Who's there? What do you mean, who's there?
And when are you supposed to have a CT scan?
CT scan's on the 27th of April.
Well, he gave her the money. He said, look. Look. I walked away. Because she asked. She came here to ask both of us for the money.
It seems like you got a lot going on with your family in terms of your mother and your father.
Right, she asked. I don't know
Is
what's
that
going
kind of weighing heavily on you at this point in
on. I
time?
think he was.
Yes,
in
sir.
all the trouble.
All right. And we have a little bit of information about you. You work as a production assistant for Spin Ultimate. Is that correct?
Yes, sir.
How long you been with them?
I've been with them for 4 years.
I always give you.
All right. Is your job flexible? They allow you to work from home, or how's that work?
No, sir. It's all in person. My job is very hands-on manual
Why she
labor,
came here.
and they do depend on me. They're a small business as well.
How are they taking, your employer that is, this issue with your parents and you having to be there for them?
I did say something.
They have
that's his
allowed me
money.
to say if I need a
He's
day
not in-
or
he's
things like
not in
that.
here. I'm in my
They
room.
work with me and try to be flexible in those things. They understand
Just
what's
call
going
him and
on.
ask him.
Okay. Are you salaried or hourly?
I'm salaried.
What did you make last year?
26,400.
I don't know why,
Okay.
Dallas. I didn't give it to
And
him.
what is
I told her I didn't have
Spin
no money.
Ultimate's juror policy?
I don't know. I mean, I'm assuming they have one, but I'm not sure what it is, Your Honor.
Oh, I'm sorry.
All right. Well, anything further, Miss Love?
No, Your Honor.
Anything further on behalf of any individual defendant? May I otherwise excuse juror 1189 for hardship?
Not yet.
All right. Juror 1189, I'm going to excuse you for hardship and wish you all the best, okay?
Thank you so much, Your Honor.
Thank you. And let me give you back this folder. I don't need it. I'll give that back to you, please.
Thank you.
On the heads up in regards to that. What I'd like to do at this point in time is just discuss with you a little bit of some pending motions that we've identified on the docket. Mr. Partridge, you You have two motions pending at this point in time. A motion to limit to exclude evidence as irrelevant and unduly prejudicial. And you have another motion to exclude any reference to a non-final conviction. Is that correct, sir?
Yeah, I'm not aware of those two motions, but for this thing, yes.
I'm sorry. Are they Mr. Hills or Mr., do we write in the wrong block or what? Do we write it in the wrong block or what? Mr. Blaylock is Mr. Peavy. Okay, all right. Mr. Partridge, I apologize. You don't have any more motions. Mr. Adams doesn't have any more motions. Is that correct, Ms. Cowan? Okay, all right. So it's on me. So, Mr. Hill, your client is the one that has these two motions pending. All right. Ms. Hyman, are you aware of Mr. Dorsey, whether he has any other motions pending? Okay, I don't think he does, but I'll certainly understand that. Mr. Johnson, I don't think Mr. Heffinger has any motions pending, is that right? Not this time? Okay, all right. Mr. Farley, Mr. Menendez, I think that we have identified you have a few motions on his behalf. A motion for bond, an amended motion to suppress his testimony from March the 16th, an amended motion to suppress statements of the defendant, and motion limiting number 2 to exclude the 16th incident, and the alternative to exclude comments on pre-arrest silence. Is that correct?
Yes, Judge. All those motions besides the non-motion involve the same facts.
Okay. All right. Mr. Matthews, on behalf of Mr. Hughey, I don't see any other motions pending for you. Is that correct? Oh, Ms. Manfred, yeah, okay. Okay, all right, madam, just let me know. If you'll send just an email copying everybody, that would be fine. Okay? Okay, Mr. Nichols and Mr. Garner. Okay, Mr. Garner, I want to say that Mr. Harvey has filed a plea in bar autrefois, and that's AUTREFOIS, convict, and motion to strike his prior plea statements. Transcripts and conduct is inadmissible, barred by collateral estoppel. Okay? Is that the only one I know that's pending? Is that right? Okay, all right. Ms. Fagan, I don't believe Mr. Bender has any motions pending. Is that correct? Ms. Bernard, other than the ones that you're dealing with currently, Mr. Myrie doesn't have any other pending motions, correct?
That's right.
All right. Mr. Garner, I misspoke a little earlier. I think that Mr. Nichols does have a motion to declare 16-11, 131, and 133 unconstitutional, and bar or strike prior convictions Act 77, 175, and 191, and current charges counts 53 and 65. That's what I have.
Yeah, I'll contact with the Harvey to see.
Okay, all right, just let me know. Okay, Misty Williams, you don't have any motions pending at this point in time, is that correct?
Not right now, Your Honor, and this is the problem coming.
Okay, but you have some motions that are pending or that are coming?
Correct.
Okay, all right, if you'll just let, like I said, your colleagues across the bar in terms of the state, as well as Mr. Kearns know, we can maybe plug you in for sometime in between these dates. When do you think you'll have those filed, madam?
By the end of the day or Monday, Your Honor.
Okay,
Your Honor, I'm sorry, Stephen Arnold, Stephen Myrick. I may have motions coming, depending on what happens.
I would assume so, madam. Okay, all right. Mr. Botts, on behalf of Mr. Stillwell, I believe you have said, you and Mr. Short have several motions pending. Motion to eliminate inadmissible hearsay, a motion for specific discoverable materials, a motion to suppress out-of-court and in-court identification, a motion to suppress evidence, a motion for an unparticularized motion to suppress wiretap recordings for failure to comply with 18 USC subsections 2510 through 20 and OCGA 1611-64. A motion to suppress fruits of illegal detention and search, and a motion to suppress item Cs. That's what we have for you all. Is that correct?
That is correct. There should be a motion in there similar to Mr. Harvey's motion.
Which one?
It would be the one concerning possession of conduct. We have separate counts for the same thing.
Mr. Kendrick, and I'm sorry, Mr. Weinstein, your client's the one that has the plea and bar.
Yes.
Ought force convict and motion to strike his prior plea statements. Okay. Transcripts and conduct is inadmissible. Mr. Nichols has the motion to declare OCGA 1611, 131, and 133 unconstitutional. Is that the one you all have as well, Mr. Botts?
Yes.
Okay, all right. Mr. Adams and Mr. Steele, on behalf of Mr. Williams, you all have some 30 motions pending. I have 30. I have a demand for a speedy trial pursuant to 17-7170. I have a motion for the prosecution to reveal specific phone calls jail calls they intend to use in evidence and provide any expert reports. 3, I have a motion to prohibit witness intimidation and abuse of prosecutorial power. 4 is a motion for disclosure of state's experts' notes. 5 is a Brady versus Maryland motion. 6 is a motion for all body-worn camera video concerning supposed evidence of 24-4-404B evidence. 7 is a motion for discovery number 4. 8 is a motion for eliminating number 3. 9 is a motion eliminating number 4. 10 is a motion eliminating number 5. 11 is a motion eliminating number 6. 12 is a motion eliminating number 7. 13 is a motion eliminating number 8. 14 is a motion limiting number 9. 15 is a motion limiting number 10. 16 is a motion limiting number 12. 17 is a motion limiting number 13. 18 is a motion to suppress number 7. 19 is a motion to suppress number 8. 20 is a motion for discovery number 5. 21 is a motion for discovery number 6. 22 is a supplement to motion for discovery number 6. 23 is a motion for discovery number 7. 24 is a motion for discovery number 8. 25 is a motion for discovery number 9. 26 is a motion for discovery number 11. 27 is a Brady versus Maryland motion number 2. 28 is a motion to exclude other accused specific offense that underlies prior convictions that are same as prejudicial at a joint trial, Mr. Williams. 29 is a supplemental motion to exclude other accused specific offense that underlies prior convictions that are the same or prejudicial at joint trial to Mr. Williams. And then 30 is a motion for Brady impeachment evidence. What have I missed, Mr. Steele?
Your Honor, on September 26th of 2022, Mr. Williams filed a motion to suppress statements while in custody as same were involuntarily made as well as made without lawful waiver of Miranda rights.
So the 26th of September of 2022?
That is correct.
Is that the filed in stamp date?
Correct. At 5:37 p.m. You actually started, if the court, I know we've done a lot, but can remember, we started this hearing. The witness is Detective or Investigator Racy with the Cobb County Police Department. And then there's ATF Agent Cunningham. We started with Detective Racy. It got late in the day and somebody had a conflict and we suspended that hearing. It was never heard.
So we need to complete that one.
Yeah, I did not at all question anybody.
That's fine. All right. And then what's your next one, sir?
I filed yesterday, and Your Honor, unless somebody opts out, I filed on behalf of everybody here, all the wrongly accused, and it's a plea and bar / motion to strike based upon race judicata, collateral estoppel, the statutory double jeopardy under OCGA section 16-1-7B as in Barry, OCGA section 16-1-8 as in Barry. And that goes to anybody who has any predicate acts that have already been adjudicated by a court of competent jurisdiction.
We heard that already.
You filed that yesterday, you said?
I did, Your Honor. You know what? Today, the days are flying on me. I think I filed it yesterday. Mr. Adams said I filed it the day before, so that would be Wednesday.
Okay, all right.
Can I just have 1 second because we did some of these, Your Honor?
Sure.
Thank you, sir. The motions for discovery, Your Honor?
Which one?
Well, no, what I was going to say is the prosecution's been nothing but professional. I'm confident we're going to work it out ourselves. But if we can't, then we could take up to the court. But I wouldn't worry about it unless they tell me differently. And arguing any motions for discovery at this point that are just titled 1, 2, or 3. If it's a Brady motion, that's different, though. I could identify which ones if that's convenient for the court, and if that's okay with the prosecution. I assume that's fine.
Okay. You've got 2 Brady motions. I think they're outstanding. Brady motion there's 1 Brady motion, and there's a Brady motion number 2.
Yes, sir. There's also a motion. Can I come back to the Brady motion in a moment, or should I flip to that?
if you have two of them, we're just identifying them. So you said we need to hear those.
Yes,
Okay, all right. Any of the motions for discovery you believe you can work out with the state?
I believe so. And
Okay, all right. So,
they've been very helpful. The state's been very helpful.
so we can hear the Brady, the two Brady motions. And what about are the motions in limine, do they have anything to do with anything that we have not covered as of yet?
Yes, it's a lot of things like confrontation clause violations, hearsay. It's for, building up the trial.
I'm sorry, what was the last thing you said?
Building for the trial. Just instead of constantly having the jurors get out of the courtroom or be excused from the courtroom. These are things identified that I believe are going to come up. I thought the court would at least want us to identify beforehand, because then you could wrestle with them if you have time before we actually get into trial.
All right, so the motions in limine we'll probably need to hear.
Okay. And then, Your Honor, on 11/29/2022, 3:35 in the afternoon, Mr. Williams filed a motion to strike from the indictment any purported lyrics or anything that he published on social media as far as freedom of expression. And this honorable court stated that we would have that argument. And there's a witness from, if you remember, from the state of, I'm going to tell you, Arizona, who is going to be here for one of the witnesses for that.
I think I deferred that until we heard, I think the state's got somebody and you all have somebody, and I was going to wait till those two witnesses, one were qualified under Daubert, and because that was in conjunction with that motion.
Okay.
Is that correct? Is that correct? Is my memory still, it's been a minute, but I think that was the way we're going to handle that. Is that right?
We're ready whenever you are. And then I
think the predicate was that we'd have to qualify them under Daubert so that I could make some type of ruling on this particular issue.
That's fine. And that was the next motion. Mr. Williams filed the motion to hold Daubert hearings. And we identified 4 experts. And that was filed on December 5 of 2022 at 5:16 in the afternoon.
Okay.
Your Honor, in addition, and I'm assuming the state will agree with this, but if we have to hear it, motion to inspect and view and test all physical evidence. I'd like everything, I'll go anywhere to look at it with our experts, independent experts. I understand the state could be there, but we'd like to just see all the physical evidence in the case as well. I presume we don't have to hear it, but if we do have to have a hearing, I'm identifying that motion.
Well, if you can't resolve it.
Do you have a problem with that motion?
I do not have a problem with that motion. We would have to coordinate that process.
And I'll only hear it if it is absolutely necessary.
Understood.
Okay. Anything else, Mr. Steele?
Yes, we have a motion. I guess we could get together first. There's a large sum of evidence that has been suppressed, and derivative evidence has been suppressed. The suppressed evidence you already ruled on, and you ruled that evidence that's derivative is suppressed. I have a list of a long list of evidence that's derivative evidence, and I guess I should meet with the state and see.
Yeah, that would be my suggestion, and I was hoping you all would do that. But I know that we've otherwise been busy with that particular issue, this jury selection, hardships, and other things. So you probably haven't had time to get to talk about that. So,
And Your Honor, I did not hear. Is that in a filing? That particular?
I'm sorry. One more time.
Is that list in a filing, or is that just one that I need to speak with Mr. Steele?
I think you're gonna need to I don't think there was anything that was listed per se. I think that when I suppressed or made that ruling that my directive was that you all get together and figure out which things would be subject to derivative potential effect from those particular things that were suppressed at that hearing.
Yes, Your Honor,
Okay.
we can do that.
All right.
Your Honor, next, and the prosecution has agreed to this, but I'd like to see if they would give it to us earlier. I have over 40,000 jail calls that I'm listening to. It's just unbelievable amount. And the state told me that they would, and they've been candid, they haven't listened to all of these jail calls, but the ones that they're going to use at trial, they were kind enough and professional enough as always to tell me that they would share those with me. I'd like to get that soon though, because I'm listening to all these jail calls when I'm jogging and when I'm lifting weights, and it's just outrageous amount of time. So I'd like to limit it if the court can rule on it, or if the state can just tell me, hey, at this point, these are the ones we're going to use, and then they can supplement. That would be great.
Your Honor, I believe that what we have spoken to Mr. Steele and Mr. Adams about and agreed to do is to identify prior to trial and to let them know prior to trial, prior to the presentation of the evidence at trial, rather, that which jail calls we've identified up until that point. And as we continue to listen to the several thousands that do exist in this case, to let them know at least, I believe we said a week in advance of the time that we intend to use them, as any information that we've provided during discovery is, unless otherwise suppressed for other reasons, is admissible, and we can use it. The sheer number of calls that are in this case should not prohibit us from using, should we hear a call that we believe is relevant, using that at trial, given that if they have enough notice of the call itself, so that they can prepare as they deem appropriate.
Okay. But everybody has all the calls, is that right?
Right. Well, the ones that we had up until a point, and then as calls are continually made, right.
You're disclosing those to the defense?
Right.
Okay, all right. I'll leave the two of you to figure out. I mean, as long as the universal calls have been disclosed, I think that's really, and if the state tells you, hey, we're going to probably use these, I think that, that would be certainly professional of them to do so, but it's still on everybody else to listen to the calls. I mean, at the end of the day, that's kind of, I know it's a lot, but however you all decide you want to do that, I'll let you decide that. My biggest thing is to make sure you have the calls, so that you can at least attempt to wade your way through them. All right?
Yeah, I think we're saying the same thing.
Yeah.
If they can give me the calls they're going to use now, or at least they believe they're going to use, that would be helpful. And then I can say it's supplement, it's ongoing. I get that.
Okay. All right.
If they could do that, that would be
Well,
great.
you mean list, because he's gonna have all of the calls.
Yeah,
And
just
as
a
we
list.
identify
Yeah.
specific ones,
If you could do that by, in a week from now, it'd be helpful to me.
we would that's exactly what we're saying, the ones that we have identified up until a certain point, and as things progress, if we identify more, we would give any defendant, time to notice rather of that particular call prior to us just admitting it on a certain day without them being aware that we're intending to proffer that particular call.
Okay. I think Mr. Steele was asking you at this point in time, Mr. Slow, if I hear it correctly, is he's asking you to at least send them what calls you have right now within a week's time that you've identified you're going to use.
We can do that. We can do that.
Okay.
Thank you, and thank you, Your Honor.
Take a quick conference.
All right. I'll just recess in place.
Your Honor, so the parking meter where I park is not gonna be up.
I don't know. No.
I'm just, okay.
No, that's a failure to plan issue.
Yeah.
Anybody else need to, because we're just trying to finish up. So if You need to go to the facilities you got right now. I'm not going anywhere. Wes. Is everybody back yet?
Yep.
Yes, sir.
Okay, all right. All right, Mr. Anything else, sir, before you yield the podium?
I yield the podium.
Okay, all right. Ms. Love, I know you probably have some things that are pending, so if you could get those to Mr. Kearns at this point in time, but I will plug in the state's motions. I think we'll have some other time periods between either because we're gonna call in our next group, as you recall, on the 28th, and then the group 7 will come in on the 19th of May, and depending upon how things go, we will have some other downtime. We'll have some other administrative time to deal with anything else that's pending. So if you'll just identify and let me know accordingly, we can go ahead and do that, okay?
We can, Your Honor, and I don't know how inclined the court would be to let us know the motions that the court is inclined to hear, so that we can make sure that.
I'm gonna do that right now.
Oh,
You know me, Miss Love. I don't like to leave people, in a lurch. So here's what I'm going to do for the motions that are pending at this point in time. So make sure you have something to write with.
Your Honor,
Yes, Mr. Weinstein.
I think you left off at least one motion that's pending to Mr. Hendricks, or the motion in the May that was filed with the first. One motion filed back here, back video.
I'm sorry. Yes, and I think we deferred that. At that time. But yes, I do remember that there was a motion in limine to exclude that particular video.
Okay, I just want to make sure, I thought Your Honor was going through all the outstanding.
I am, and that, no harm, no foul, sir. No harm, no foul.
Thank you, Your Honor.
Okay, so there's still a pending motion to suppress on that one. Motion in limine, I should say.
Like, and there's also a motion to suppress statements of defendant filed on that same day.
I think, yes, you got a motion to strike his prior plea statements, transcripts, and conduct as inadmissible, barred by collateral estoppel.
Yes, Your Honor.
Okay,
Thank you.
that's what I have, and I think I still have the motion in, I think the motion in limine, but that motion to strike the prior plea statements I do have.
Thank you.
Okay, all right, so let me go ahead at this point in time. Mr. Hill, you should be prepared on the 17th of April to argue your motions. 17th of April, we will start at the regular associated time of probably around 9 o'clock. So I'm going to there's going to be 3 sets of folks that are going to have motions on that day. So Mr. Blaylock, you'll have motions on that day. Mr. Farley or Mr. Menendez, you should be prepared to argue your motions on that day on the 17th of April. And the state, Ms. Love, you're just saying those particular witnesses, you can, I think the same witness for these particular motions, we'll be able to hear those on the 17th. And then, Mr. Weinstein, we will hear the plea and bar ultra first convict and the motion to strike the plea statements on that day, on the 17th.
Thank you, Your Honor.
Those 3 motion sets will be heard on the 17th of April during that day. So I want to exhaust that particular day's worth of motion. So councils, As for the 18th, that will be an administrative day. All right? Mr. Botts, on the 19th, starting at 2 o'clock, I will hear your motions. Mr. Stillwell's 6 motions at that point.
2 o'clock?
2 o'clock. Hold on. Wes.
Who's talking this second, Bill? I'm sorry.
I was judge. Just wanted to clarify, administrative day on the 18th means, you're not handling any matters on that day?
No, it means I won't be handling anything involving you all in court. That doesn't mean that you don't have other business or other things. You still have discovery and other issues that you need to take up. You can take up, or other business you can take up, with the caveat you're still in trial in this case. I will also probably make the 21st a administrative day, as I have a judicial council meeting in Columbus, Georgia. So it's in person. So I will be gone most of that day. So the 18th, I should say the 21st will be an administrative day, as well as the 18th. So the 18th is a Tuesday, and 21st is a Friday. Those will be administrative days. Now, let me finish that. Was that answer your question, Mr. Adams?
Yes.
Okay. Now, for the afternoon of the 20th, Mr. Gardner, you can let Mr. Harvey know that his motion will be argued the afternoon of the 20th of April. That's that Thursday.
No time.
starting at, yeah, you really? Really? No time? I'm gonna give you a time right now.
You said afternoon.
I said afternoon, I said, but yeah, you jumped the gun. I was gonna tell you the time till you cut me off. All right, how about 2 o'clock? Two o'clock, sir. Okay. Thursday the 20th. Okay.
Yeah, I gotta clarify, you know.
No, you're late. Too late.
Okay, I got it.
What did you have, madam?
We have no pending motions, that's confirmed, however, we do.
You reserve the right to file additional motions?
Yes, Your Honor.
Okay, that's fine.
Okay,
But you don't have anything pending right now.
correct.
Okay, all right, no problem. Okay, but thank you for that update. Okay, all right. Mr. Adams and Mr. Steele, okay, starting on the 24th of April, I'm gonna try and hear your motions and your two Brady motions and your motions in limine. But the thing I'm trying to figure out for at this point in time is, you have 4 experts that are subject to being that Daubert. Will that give you, how many of those can we handle or deal with from the 25th through the 27th, or 24th through the 27th?
One is local, and I've got to check with his schedule. His name is Jim Persinger, which is PERSINGER.
Mm-hmm.
The other 3, Your Honor, are from the Commonwealth of Virginia, California, state of California, and then Arizona is my member. Okay, Nevada. So I just have to check their schedules, but they're aware that Your Honorable Court, I told them that Your Honorable Court delineated the 17th to 27th for motion, so they're aware that they may be coming.
Okay. I just want to make sure we have enough time because they from our prior Daubert hearings, they take a little bit. So is it possible for you to make those inquiries today and report back to me on Monday?
Of course.
So we can go ahead and schedule those particular individuals for 24 through 27 April?
Of course.
Will that work?
Yes, that'd be amazing.
Okay. All right.
Now, you said the 24th?
Yes.
Okay.
Starting the 24th. So I'm pretty flexible at this point in time, but understanding that I'd like to at least try and exhaust some of those. And whatever I don't get heard, I will, as I told Ms. Love earlier, that we will have another period of time between we are finishing group 7 and potentially having to call in some other folks depending upon what we have left. Okay.
Thank you.
Thank you so much.
Okay. So we'll check back on Monday, and if we could, I'll just make a note, and you can let me know, and then we can schedule accordingly. Okay.
Yeah.
All right.
You see, both of them got their head down. Doug and Shannon. Jeffrey and Shannon. Sorry, Jeffrey.
And for those of you who file additional motions, just let us know. So of course, copy your colleagues applicably, but let us know, Mr. Kearns in particular, so we can go ahead and schedule those or make sure that they are heard appropriately.
Yes, Your Honor.
All right.
Yes.
All right, hold on, y'all. I'm gonna go to the next one.
Okay, folks, at this point in time, are there any other administrative inquiries of me or any other things that I need to know about?
Not from the state, Your Honor.
Your Honor, and I know that talking meeting is running. Can I have 1 second before I say no? Can I just talk with counsel for Mr. Kendrick just for 1 second?
Yeah, sure.
Thank you. I apologize.
Anything further, sir?
Yes, sir. Your Honor, if this assists the court and the parties, this honorable court scheduled for Monday, the 17th of April, 2023, Mr. Diamante Kendrick's collateral estoppel motion. That motion is assumed in the motion that Mr. Williams wrote and filed 2 days ago. That's a joint motion. I spoke with counsel for Mr. Kendrick's. They would like to, and obviously I'll bow down to whatever he says, withdraw hearing that motion on that date because it will be included in the presentation I make to the court. So you wouldn't be wasting time, if that helps you. And then you might have more time on the 17th. But I just wanted to alert the court that I knew that motion has now been adopted. Basically, they're not waiving anything, but they are using the motion that Mr. Williams filed 2 days ago. Rather than
Is that the plea and bar?
my motion?
Yes.
Yes. And I wrote plea and bar / joint. It's for everybody. Joint motion to strike. And that will, so the court would not have to spend the time with Mr. Kendrick. And that's why I wanted to speak with counsel.
And that's accurate, Your Honor.
Ms. Love, would that give you all a sufficient time to address Mr. Steele's motion, assuming that Mr. Kendrick's motion is consumed in that plea and bar or joint motion?
Which date, Your
The
Honor?
one that's filed for the 17th of April. It was filed on the 5th of April, so it would probably be ripe somewhere around the 17th.
Your Honor, if the court would give us an opportunity to respond to that question on Monday, I believe that we could. Okay, I appreciate that, Judge. And so in essence, rather than just hearing Defendant Kendrick's motion, we'd be hearing.
He's withdrawing that motion, or at least that's what I understand it, because it's consumed within the motion to plea and bar and the joint motion.
And the court would then hear Mr.
I would hear Mr. Steele's motion, substitute Mr. Steele's motion for
Understood.
that.
Okay. Thank you, Judge.
Your Honor, to, while on the top of that, Plea and bar, Justin Hill had Mr. Wells, by the way. I was at some point in the future going to file a similar motion, so if, I guess, just let the court know if I may also be heard, as it relates to Mr.
Not until you file a written motion, young man.
Sorry?
Not until you file a written motion.
I'm referring to the same motion that, Mr. Steele.
You need to file a motion.
Okay, yes, Your Honor.
And unless you say you adopt Mr. Steele's motion, now if you adopt it, that's fine. And I think that Mr. Harvey did a solid for all of you and said that was, I mean, unless otherwise indicated you don't want to opt in, that it applies to everybody.
But I was not understanding the court know that I did what you heard, that was the honorable court wish.
Only if you don't replicate what everybody else says. Okay, all right. Yes, young man, that is fine.
Thank you, Your Honor.
Okay. All right, do I have anything else? If not, folks, for those of you that celebrate, have a good Friday, happy Easter, and we'll see you all on Monday the 10th, okay?
Thank you, Your Honor. Thank you.
At 10 o'clock. All right, we are in recess.
Attorney, before you leave, see Deputy Stanley. I know you put your client's clothes the next week outside. See Deputy Stanley, raise your hand. See Deputy Stanley, and she's gonna have some paper for you guys.
All right, guys, that was it. That was it. And I didn't disturb y'all from, I didn't talk too much, except when I was on the phone with Miss C. I was on the phone with Miss C. And I forgot that if I mute, it would mute the whole thing. So I had to step away for a minute. Hey, Mary. Which one? Okay, that's basically it for tonight. I'm done with this because I need to go to the back with my peeps. All right. You guys have a great one. Mary, I'm gonna have a what's the name? Members only in the back. So I'll see everybody else tomorrow, if God's willing. You guys have a rest of a good Friday, and see you tomorrow, if God's willing. Later.